in breach, however, if this standard, however, if the inaccurate data was provided by the data subject or a third party. However, the data controller would be required to take reasonable steps to verify the accuracy of the data. Now, the fifth standard is that personal data must not be kept for longer than is necessary and must be disposed of in accordance with the Act. Note, however, that this is subject to any applicable retention periods prescribed by law. So if outside of the data protection legislation, you're governed by another legislation which says that medical information or health information must be kept for 7 years, right? You'd be fine because the legislation says that, right? But if it is that there's no law that says that you should keep certain data for a certain time period, and there's no real reason for you to keep that data, then you must dispose of it. Now, the sixth standard is that personal data must be processed in accordance with the rights of the data subject. And I had discussed those rights earlier on. Now, the seventh standard is that personal data must be protected using certain technical and organizational measures to prevent unauthorized or unlawful processing or other security breach. So, as I said before, I will go into more details regarding these technical and organizational measures. And the eighth and last standard is that personal data must not be transferred to a state or territory outside of Jamaica unless that state or territory ensures an adequate level of protection. Now, this would have a significant impact on entities or individuals who store data using cloud computing services, because most of these services are provided outside of Jamaica. So if it is that you have to transfer personal data outside of Jamaica, you have to ensure that whichever country, whichever state, whichever territory it is being transferred to, that they too have similar data protection legislation and similar data protection obligations. Now, not only is the data controller required to register with the Information Commissioner, but the data controller is also required to submit a data protection impact assessment. So to conduct as well as submit a data protection impact assessment annually to the Information Commissioner. And this must be submitted within 90 days after the end of the calendar year. So it must be submitted every March. Now, the purpose of the data protection impact assessment is to basically identify and assess any potential risk which may arise from processing personal data and the measures taken to reduce or minimize those risks. So you'd have to identify all the personal data you have in your possession, whether it is just personal data or whether it is sensitive personal data, and what are the risks, if any, that can arise from processing these personal data. And if there are any risks, what are the steps being taken by you as a data controller to avoid or minimize those risks? Now, the data controller is required to report any security breach to the Information Commissioner within 72 hours after becoming aware of the breach. So say, for example, there was a cyber attack on the software that you used, or there was accidental deletion of personal data, or sensitive personal data was disclosed to an individual or mistakenly sent to someone who should not have access to that information. You have to make a report of this to the Information Commissioner within 72 hours after it's happening. The data controller is also required to report any security breach to each data subject whose personal data has been affected. So you'd also have to notify the data subject that there was some sort of breach as it relates to their personal data. As I said before, if it is that health information was disclosed to a third party who should not have access to that information, you have to notify your patients about this. Now, there must be a legal basis for processing personal data, and the Act outlines a number of those legal bases, and you have to satisfy one of those legal bases. You have to show that one of those legal bases exists and that you're relying on one of those legal bases to process personal data. So I just highlighted a few of those legal bases which I believe would apply to healthcare providers. And one of those legal bases is where the data subject has given his or her consent. So you always want to ensure that you obtain the consent of your patients, prior to processing their personal data, because this is something that you can rely on when it is that you're processing their data, when it is that you're collecting their data. Another legal basis is where the processing is necessary for the performance of a contract, right? Or to take steps at the request of the data subject. So the processing will be necessary for you to provide the healthcare services. The patient comes into your office, it's requesting healthcare services, and so you have to collect certain information on them in order to provide those services. So that's another legal basis that you can rely on. Or where the processing is necessary to comply with your legal obligations. So there are certain due diligence, KYC information that you have to collect, right? And this is in order to comply with legal obligations, as well as information that you collect on your employees. This is required to comply with certain employment law obligations. Another legal basis is where the processing is necessary to protect the vital interests of the data subject. So this is where you have to collect certain health information about an individual in order to properly administer healthcare to them. So this is another legal basis that you'll be able to rely on. And the same thing applies when you're processing sensitive personal data as well. You also have to have a legal basis, which is similar to when you're processing personal data. And consent as well, but as it relates to sensitive personal data, the consent must be in writing, right? It has to be in writing. I discussed this before. Now, what are some of the legal implications for if it is that you are found to be in breach of the legislation? Now, an entity can be liable to a fine not exceeding 4% of its gross worldwide income. Now, a director or secretary or senior officer can be held personally liable if it can be proven that they were negligent or consented to the offense. Or an entity may be liable to pay compensation to an aggrieved person, that is anybody who can prove that they have suffered some sort of damage as a result of the breach. Now, I know that a lot of doctors, they have like sole proprietorships, they don't really have companies, and what the act says is that you can be fined. The fine goes as high as $5 million and or imprisoned if it is that you're found to be in breach of the act. Now, there are a number of exemptions that are set out under the legislation, and if it is that you're processing personal data, and it can be, it fit within any of the exemptions, then you can be exempted from a number of the provisions under the Act. So not all of the provisions, but some of the provisions under the Act. So if it is that you're processing personal data for the purposes of preventing a crime or assisting with the investigation of a crime, there are certain provisions under the legislation that you will be exempted from, like, for example, the right of access, because the data subject wouldn't be able to be provided with that information if it is that you're processing the data to assist with a crime, right? Another exemption is where the data is being processed for research purposes, which includes that statistical or historical purposes, or where the data controller is obligated by law to process the personal data. So if it is that the processing falls within any of those exemptions, the data subject's right of access, they may not be able to exercise that right. They may also not be able to exercise their right to rectify any inaccuracies in the data or to prevent the processing of their data. Now, what are some of the steps that you can put in place to ensure that you're compliant with the Act? Now, firstly, the first step is to appoint the DPO, right? It's very important. And the DPO, as I mentioned before, is the data protection officer. That's the first step. And what the data protection officer can assist you with is to monitor your compliance with the Act, right? The data protection officer can inform, can advise, and issue recommendations to the data controller, can assist with managing internal data protection activities, can assist with training staff and conducting internal audits. The data protection officer can handle complaints from the data subjects and liaise with the information commissioner. But the data protection officer must receive active support, from senior management or, from the doctors. And there must be safeguards put in place to enable the DPO to perform his or her task independently. There should also be no conflict of interest with the DPO's possible other tasks and duties. And there should be no dismissal or penalty. If it is that the DPO is an employee, right? There should be no dismissal or penalty of the DPO for the performance of the DPO's task. Now, most importantly, it is very important to obtain consent because this is the best form of protection, right? Always try to obtain the data subject's express consent prior to collecting, storing, using, and disclosing their personal data. You also want to implement certain procedures for obtaining parental or legal guardian consent in the case of a minor. Now, consent must be informed, must be freely given, it must be specific and unambiguous. So if it is that you are collecting their personal data for 5 different purposes, you must inform the data subject about these 5 different purposes. Let them know that you'll be using their personal data for these 5 different purposes and get their consent to that, right? You also want to ensure that consent is recorded so that, if it is that you have a claim against you, you can show that you did obtain the data subject's consent. But bear in mind, however, that a data subject always has the right to withdraw their consent. So not because they have given you consent means that it's definite. They can always withdraw their consent. And so you have to therefore make a determination as to whether it is you'll be able to continue providing them with a specific service if it is that they choose to withdraw their consent. Now, policies. You want to start by implementing certain policies, within your organization, certain policies and procedures, which will govern the way in which personal data is collected, how it's stored, how it's used, how it's retained. So for example, you want to have a privacy policy, and this privacy policy would set out the type of data that you collect, how is it that you process the data, or the purposes for which you use the data, what are some of the security measures you have in place to ensure that the data is being processed in a manner that is confidential, secure, and who would be the data protection officer. You'd set out all of that in a privacy policy, and you will have, your patients consent to the fact that they have read the privacy policy, they understood the terms of the privacy policy, they agree with it, right? And they consent to you processing their personal data in accordance with the privacy policy. You'd also want to have certain retention policy that talks about the different types of data you have and how long it is that you're going to retain that data and what your disposal or your destruction process is like. You'd also want to have certain policies that put in place in the event that there's a security breach. What is the next step? If it is that a data subject wishes to exercise their right under legislation, how will that be done? So you want to put all of those policies, all of those procedures into a policy type document, right? And these policies must be written in plain and clear language so that both your employees and your patients can understand. You also want to ensure that your patients and your employees agree to be bound by the terms of the policies. And it is also recommended that third-party service providers engaged by you be required to comply with the policies as well. Now, it is very important to also conduct security audits. It is recommended that you do. These security audits can be conducted quarterly or annually. And what these audits will do is to give you an opportunity to do an assessment of all the personal data you collect to see whether it is that, operated in a manner that is compliant with the legislation. The security audits can also assist you with determining whether you're collecting too much data. Is it that I'm collecting too much data that is not really relevant to my practice? Is it that I need to start getting rid of some of these data? It will give you an opportunity to ensure that your entity is operating in accordance with both local and international data protection standards. You'll also have the opportunity to review existing contracts that you have in place with your employees and with your patients and your suppliers, and you want to ensure that they're also compliant with the legislation. Now, the roles and responsibilities of key personnel must be clearly identified. Employees' access to the personal data ought to be restricted and based on a need-to-know basis. So not everyone needs to have access to personal data, especially sensitive personal data. And not everyone who works with you needs to have access to the data. So all employees who have access to the personal data should be subject to confidentiality or non-disclosure agreements, right? And you ought to have mandatory training sessions, whether quarterly or annually, to ensure that your employees are properly trained in the handling, storage, and disclosure of data. Employees should also be required to report any actual or suspected security breach as soon as it occurs. Now, the Act expressly states that the data controller must implement certain technical and organizational security measures to prevent any unauthorized or unlawful disclosure of the personal data, right? And, some of these measures would include like engaging the services of an IT firm, right? If it is that you do not have someone who works within you who works in the area of IT, you may consider engaging an IT firm. And what the IT firm can do is assist you with implementing, a sort of security governance framework. You want to ensure that whatever software you're using to store the personal data, to ensure that it is safe, it is not easily penetrable by a hacker, and just to ensure that the data that is stored there will be kept confidential. Now, if it is that mobile devices are being used, and computers are being used by employees, you want to ensure that it's protected by a strong password. It should be very important to stress to everyone that, your devices should be protected by password, should have multi-factor authentications, and the strong passwords are those that are a combination of at least 10 lower and uppercase letters, numbers, and symbols. You also want to use secure communication channels for sharing personal or sensitive data. For example, email encryption, because what the legislation is saying is gone are the days where you just send an email to another person and attaching a document containing sensitive personal information. What the legislation is saying is that when you're sending emails that contain sensitive personal data, you should ensure that the email is encrypted or the document is encrypted. And the recipient of that email would then receive a key or a code. And they would only be able to view the information if it is that they have that key or code and uses that key or code to unlock it. So now you would have to stop sending emails by just attaching documents to the emails. Well, the Act is saying that the practice should be stopped, and going forward, you should ensure that all emails are encrypted. Now, you want to double check email recipients before sending emails, especially those containing sensitive information, because you do not want the information to be disclosed to the wrong person or to get into the hands of the wrong person. So always double check your emails before sending, right? You also want to use secure print features that require a unique code or ID badge to release print jobs, right? And you want to ensure that documents are not left unattended at the printers, which I find to be a very common practice. Now, the personal documents of your patients and your employees must be stored using a secured method, either a safe or locked filing cabinet. So you want to ensure that these cabinets are also fireproof and waterproof, so that in the event of a fire or in the event of a flood, the information will still be safe, the information will still be secured. And you always want to ensure that documents are stored within these cabinets and not left on your desk or left somewhere unattended, right? And personal data stored on mobile devices must also be password protected, and you want to ensure that you have some sort of system put in place where in the event of a theft, the device can be remotely wiped. You also want to implement what is known as a clean desk policy, where all sensitive documents are removed from your desk. So you don't want to have documents lying around on your desk for every employee to see, or not only employees, but what if you have another patient who visits you, right? You want to ensure that you don't have sensitive personal data lying around on your desk. Always make sure that once you're no longer using it, you securely store it. Also want to use privacy screens to prevent others from viewing your monitor, especially when it is that you're working with sensitive information. Now, documents which consist of sensitive personal data must be destroyed with paper shredders after being processed. So do not just fold it up and throw it away or crush it up and throw it in the bin, especially if it contains sensitive personal data. You want to use that paper shredder to make sure that, the information is not retrievable. You also want to ensure that whatever software you're using to collecting the data, or whatever antivirus software you're using, you want to ensure that it's effectively maintained and up to date to prevent any viruses, from gaining access to any confidential information. You also want to use a VPN when you're accessing, the network remotely to ensure a secure connection, right? You also don't want to be logging on to any public Wi-Fi, especially when it is that you're going to be viewing sensitive personal data. You also want to designate areas where sensitive information is handled, right, as restricted with access controls in place. And you may also want to consider implementing surveillance systems to monitor access to areas where sensitive information is handled. Now, another step that you can start by doing is creating an information asset register, right? Because this will assist you with tracking all the data that you have in your possession, and it can also assist you when it comes to registration. And what the information asset register does is you have an Excel spreadsheet, you list all the information that you collect, the type of personal data that you collect, the purposes for which you collect it, whom did you collect it from? If it is that you're going to transfer this data to a third party, who is the third party that you're going to transfer it to? Where is it stored? Who has access to it? So you want to just create a table outlining all of this information, because at the time of registration, you'd also have to provide the information commissioner with all this information, as well as you'll also want to have a record of all your processing activities as well, because you'll have to provide the information commissioner with this information, right? What is the legal basis you're relying on to process the personal data? So you will set that all out in a table. And that's something that you should start implementing by now, right? Because this is something that you'd have to do throughout your entire practice. And lastly, as it relates to data processors, if it is that you're going to be using a data processor, you have to ensure that, whichever data processor you use, that they have certain guarantees in place and that they have sufficient security measures in place to protect the personal data, right? And if it is that you're using a data processor, there must be a written contract in place with the data processor, right? Going forward, you have to have a written contract in place, and that written contract must state that the data processor can only act on your instructions. You also want to ensure that the contract also states that the data processor must comply with legal obligations similar to yours under the legislation. So to conclude, the Act became fully operational on December 1st, 2023. And given the severity of the fines and penalties, it is important for you to start putting your affairs in order to avoid and/or minimize the risk of a security breach. So I will now open the floor to questions. I believe you can either raise your hand if you have a question, or you can type it in the chat.
All right, so I do believe we have one raised hand so far. And Aldi Buckland, you can go ahead and unmute and ask your question.
Thank you. Just got unmuted. Good evening. Thank you so much for the presentation. My question is, so I've been seeing patients for over 7 years. So I have more than 7 years information. And if the person uses health insurance by contract, I am to keep that information for 7 years from the last entry. Now, is it then that I can give my patient 7 years further back and give them that? Or am I to destroy it?
No, because as you said, you would be required to keep the information for 7 years, right? And that is to comply with your other obligations as it relates to insurance, right? For the purposes of insurance. So it's fine. You can keep the information for 7 years, because that would be the legal basis that you would rely on as to why it is that you're keeping the information.
Right. All right. Say asking somebody, say, for 14 years, and the person has been using insurance maybe for the 14 years, but I'm going to keep the recent 7 years, and I can give the other 7 years to the patient, or should I destroy it or have a conversation with the patient since it's their information?
I mean, because is there a reason, what's the main reason why it is that you'll be keeping the information?
There
Because
is no,
outside of insurance purposes, there's no reason for you to keep the information. That's what you're saying.
right.
Right. So if there's no longer a reason for you to keep it, then it's time to dispose of it.
Okay, in disposing, am I just to dispose of it, or should I have a discussion with the patient, the data subject?
No, you don't need to have a discussion with the data subject because you're not obligated by law to keep it, right? And it's not a situation where the data subject says or asks you to keep it for a specific time. You're not obligated by law to keep it. So you don't have to have a discussion with the data subject every time within which you're going to dispose of the data. And that's why it's also important for you to have a privacy policy in place, because in this privacy policy or retention policy, you will state that you'll only be keeping their data for a certain time period. So they would be aware at the point in time when, they sign up to be your patient, they would be aware that this is the length of time that you'll be keeping their information. So you no longer have to report to them or inform them every single time when you're going to dispose their data.
Thank you. Thank you very much.
You're welcome.
Okay, so we have in the chat a message from Dr. Mario Guthrie. For the DAISY users, does DAISY, which is Pharma Online Limited, function as our information processors?
Yes, because DAISY will be processing the information on behalf of you, on your behalf.
All right. We also have Christina Ramsey. She didn't catch the presentation. I'm going for the question. Can you share how this applies in the public healthcare setting and major points for healthcare workers to be aware of that will have to handle information, especially in cases where registration is being done in a space where adequate privacy is not there?
Okay, so based on the fact that being in the healthcare center, you will be collecting personal data as well as sensitive personal data, right? You'd have to ensure that the way in which you're collecting data, it is in compliance with the legislation. Because the legislation, as I said in my presentation, applies to data controllers. And what it does is it protects personal data and it governs the way in which personal data is used or is processed by data controllers. And being the fact that you're in the healthcare center, you're a medical doctor, I'm assuming, and you collect personal data, you collect sensitive personal data, you'd be regarded as a data controller and would therefore be required to comply with the legislation. As it relates to the registration, I'm not sure I 100% understand your question. Is it that you're saying the form in which you'll register, as in through the website, you're saying that there's not adequate privacy there?
No, I'm assuming she's talking about a patient registering. I'd like to not assume. Could you open your mic and ask the question? Is that possible? All right, in the meantime, we'll go on to another question. Dr. Simone Chung, welcome. She says, good evening. Can you please tell us how to register as data controllers?
So the registration process will be done electronically, and you will register via the Office of the Information Commissioner's website, right? The website is now launched. The website is www.oic.gov.jm. So you can go on that website, you can set up your account, and you can register to the website. Bear in mind, however, that the registration form is not yet available, and it won't be available until the regulations which govern registration have been passed. So my understanding is that the government is currently working on finalizing those regulations. We don't have a date as yet as to when they will be finalized. But once they're finalized, they will inform the public, and then you will be able to register.
Okay, Sadie Robertson, do I need a consent for each purpose that I will use their info for, or one consent that lists out the different purposes?
So it's best to have a consent that lists out all the different purposes. So if it is that you want to use consent, you will list out all the different purposes, and you will have like a checkbox for the patient to tick all those boxes to say, yes, I consent to you using my data for all these different purposes.
If one patient is, we're looking at Dr. Jennifer Brown Morgan. If one patient is post 7 years old and another only post 4 years, then how do I destroy the document? Many patients on one insurance document.
I mean, but it's also based on your practice and how is it that you collect data, how is it that you store data, and what are your internal procedures and practices? Because what the legislation is basically saying is that you should not keep the data for longer than it is required, right? If it is that you still require the data, then you have that as a basis as to why is it that you're not destroying the data. It's only if it is that you no longer require the data, then you should dispose of the data. So if you have one patient that's post 7 years and another one that's post 4 years, I believe that this is an internal practice, meaning that you only keep data for post 7 years. I don't know if it is something that is required by law, or that is something that is a practice amongst medical doctors, but whatever it is that your internal practice, right? You only can keep the data for that time period. I mean, I don't think you have to worry much about that. You just have to be able to prove that this is your internal practice. This is how long I'll be keeping your data for. And after 10 years, after 11 years, I'll be destroying the data. It's what fits within your organization as well. It's not a situation where, and as I said before, the retention period is subject to also retention periods that are prescribed by law. So if it is that the law says that you should keep the data for post 7 years, right? But you have a patient that is only post 4 years and is only on one document, then you can't dispose of it, because it's not time for you to dispose of the one that is only post 4 years. So you have to have some sort of legal basis as to why is it that you're still holding on to the data. But I'm not sure what the practice is like as it relates to insurance. Is it that the information has to be only on one document? Can't it be on a separate insurance document? I'm not sure how is it that is done. Because maybe you'd have to look into separating the information and keeping the information on separate insurance documents, if that's possible.
All right, we have a raised hand. I've asked to unmute. Titus? You can go ahead with your question.
Hello, good evening. Can you hear me?
Yes, we can hear you.
Okay, great. I have a couple of questions actually. Hopefully I'll be able to go through them quickly. One, you spoke about consent earlier, and there are a couple of places where I work where we do have a consent form, and we have a listing where basically, as you mentioned, you tick off exactly what you're going to be using the information for in terms of if you have to transmit it for a patient. So my question is, does the consent form, how long is a consent form valid for? Is it valid for a month? Is it valid for a year? Do we have to keep the getting consent for the patient every time they come for an interaction with us? How long is the consent form valid for?
So there's no time period as to how long the consent form is valid for. Whatever service it is that you're going to provide to the data subject, or whatever purposes within which you would be using their data, you would set that out in the consent form, and you'd have them consent to that. And so long as you use their personal data for those specific purposes, then the consent will be valid for that. You would not need to obtain their consent, right? You won't need to obtain their consent each time that you're going to be using the personal data for the purpose for which they already consented. The only time you would require additional consent is if you're going to be using the data for another purpose for which they did not previously consented to. That's the only time within which you would then need to seek their consent or additional consent or further consent.
Okay, my next question, thank you. My next question is, what if there is a case, and this happened to me recently, where a patient had asked me to send some information, and she actually gave me the wrong contact information. So how do you go about handling a situation like that?
So as I said in my presentation, you must always try to ensure that the personal data that you obtain is accurate and up to date, right? But you would not be in breach if the inaccurate data was provided by the data subject, right? So that would be a fault of the data subject and not a fault of you.
Okay, and I think this would be my last question. I'm not sure if you answered it before. I did join late, so sorry, I may have missed some parts of your presentation.
That's fine.
With respect to, well, I'm in the area of obstetrics and gynecology, and our area has quite a bit of litigation. Thankfully, not as much as North America, but I mean, the winds are changing. What about the possibility of, yes, I see people banding about that we should keep records for 7 years, but there could always be the possibility, especially in my field, where somebody could decide, okay, 8 years later after the delivery of a baby, some issue comes up with their child, and then they say, oh, but this is related to a problem that happened during the delivery process. So for us in certain fields, it makes sense even past the prescribed period to keep certain records, especially if you know that you had a particularly difficult situation with that patient, and you figure that maybe, okay, you know, this person might in future want to persist or to pursue, I should say, a case against you.
Right. So in that situation, you would be keeping the personal data in order to exercise your right to defend a legal claim, right?
Yes, that's correct.
So that would be the legal basis as to why you'll be holding on to the data for a much longer period. So that's fine. You know, what the legislation wants to know is that you have a legal basis for holding on to the data, and that would be to exercise or defend your legal claim. So as I said before, you could cure this by having a privacy policy as well. And, you know, in that privacy policy, you would set that out, that, you know, these are the reasons why I'll be holding on to your data for a certain time period. And that would be one of the reasons, because you want to be able to have this information to defend a legal claim in the future. And they would be aware of that at the point in time when they come to you for the service, right? Or at the point in time when they're signing up the patient form. They would be aware that there's a possibility that you'll be holding on to their data for a much longer time period.
All right, thank you. Those are my questions.
You're welcome.
All right, we have from Dr. Donald Chen. I work part-time at a center. They booked the appointment and collect the fees. The medical center keeps the records. I only get paid on a monthly basis. Should I register, or the medical center should be responsible for the data keeping?
Well, if it is the medical center who is the one who collects the data and keeps the data, then for that purpose, it's the medical center who would be regarded as a data controller. You have to bear in mind, however, that there can be joint data controllers. So even though the medical center could also be seen as a data controller, you could also be seen as a data controller. But you have to go back to the definition of who is a data controller. and the data controller is the individual who determines the purpose and the manner in which the personal data is processed. So if you have some sort of control over what information is being collected, how is it that the information is being processed, then you could also be regarded as a joint data controller. But based on your question, it would seem to me that you don't collect the data any at all, right? It is the medical center who collects the data. I don't know if you want to unmute and have a further discussion on it as to whether it is that you're the one who collects the data, or is it only the medical center who collects the data and keep the records? Because it could be a situation where it could also be regarded as a data controller, if it is that you're the one who is collecting it. Because it needs to be very clear whether it is that the medical center is only keeping the records on your behalf. Is it that they're processing it on your behalf? Or you can respond in the chat.
Unable. Yes, I'm just saying. They book the patient. I see the patient. I don't keep any record, and I just do a general practice for them, so to speak. I don't operate for them. I don't have any operating notes. I don't operate. Can you hear me?
Yes, I'm hearing you.
Yeah.
Right. So it's the medical center who
It's
so
responsible.
Responsible for collecting the data and for storing the data and keeping the data,
Right.
and you don't take the data any at all. You just
No,
be
I
that
don't
medical
keep the
center.
notes.
You just
Right,
see
so
the patient.
I just see the
You
patient.
just see the patient. Okay, so it wouldn't be you who would be required to register. It would be the medical center.
Right. Okay.
Correct. Yeah.
And I suppose is that any doctor working with the government too, if they don't have any personal collection or interests apart from doing the job
For the
and
government.
taking care of the
Right.
patient.
Right.
Okay.
Right. That's correct.
Thank you.
Okay. Thank you.
You're welcome.
All right, we have another question regarding DAISY. Will there be representatives from DAISY who will be functioning as data protection officers? That's from Katie and McCall.
I believe that question is for you, Shani.
Not certain as yet. I'm scrolling through to ensure that I have mentioned everything. Does processing the data and accessing the data mean the same thing?
No, that's a very interesting question. Well, processing the data is collecting the data, storing the data, using the data, destroying. There are a lot of things that could be regarded as processing the data, right? So when you say you access the data, is it that you only, for example, just review the data on someone else's computer, on someone else's system? What do you do with the data after you access it? And this question is from Dr. Cheryl Burke.
Right. So let me see if I could find her and ask her to unmute.
Is it that you only view the data?
Dr. Burke, could you unmute and give us some clarity on your question?
Can you hear me?
Yes, I'm hearing you.
Okay, great. Thank you. Very comprehensive presentation, very enlightening. What I wanted to ask is, in a situation where the file, whatever your record is, whether it's electronic or whether it's paper-based, where your file is kept by a source, whether your medical center or whatever, and you need to access the data in order to see what is happening with your patient, review past studies, whatever, not necessarily to send it out anywhere, but just to access it in order to deal with whatever situation presents itself at the time that you're seeing the patient. Is that considered processing?
So basically, it's like a scenario where you'd work at a medical center and they would have collected the data and have the data stored somewhere, whether it's electronically or paper-based, and then you would then go and just view it for the purposes of providing a service. That would not necessarily be seen as processing the data. Because the processing, it is the medical center who would be processing it because they're the ones who collected it and they're the ones who are storing it.
Right. Okay.
Right.
Okay. All right. Thank you.
You're welcome.
Okay. I'll mute now.
Okay, we do have another question from Dr. Aaron J. Brown Morgan. What is this chart where to keep logging daily? Also, there's very little information obtained from a patient which isn't relevant in general, well, GP practice.
Okay, well, that's good, because if it is that most of the information that you collect is relevant, then, I mean, that's fine. You know, there would be no breach there because there's a need for you to collect it. As it relates to the chart that you should keep logging daily, you may not necessarily have to update that chart daily, but what the chart is basically a template that assists you with logging the personal data that you have in your possession. And I mean, whenever it is that you collect the personal data, you want to have it set out in a chart, and it's basically a record that you keep. I mean, it's known as an information asset register. And it will assist you greatly in your day-to-day operations, right? Because as I said before, what you do is you set out what type of personal data you collect, right? Who collects the data? You will state who has access to the data. If the data is disclosed to a third party, another medical doctor, an insurance company, you would provide that information as well in the chart. And it's really for your internal purposes, so that, you know, if it is that you have a data subject who wishes to exercise his or her right, you can simply pull up the chart and look on it and say, yes, I have this information on this person. This is the information that I have on them. This is what was done to their information. So it's really to assist you with their day-to-day operations, and it's really an internal document. But it's not necessarily something that you would have to update daily if there's no information to be updated on a daily basis.
Okay, so it seems we have no new questions.
No, I believe there are
Wait.
yeah, we have there.
We have another raised hand.
Persons are able to unmute themselves now.
Okay, great.
Thanks for this opportunity again. For doctors who work in a medical center, they're just working and then they collect whatever they earn. However, I think in the process of seeing a patient, history and examination occurs, and then documentation also occurs. And to me, that is collecting information and writing it down. So isn't that doctor a controller?
No, but then in that situation, you're working on behalf of the medical center, right? You're not working as an independent medical doctor. You're regarded as an employee of the medical center. Is that the case?
Yes, yes.
Right. So if you're an employee,
seems to be, yes.
Right. So if that's the setup, then that means you're working on behalf of the medical center, who would be regarded as the data controller.
Right. Thank you. Thanks for the clarification. Could you go through your DPIA, your data protection impact assessment? How you do that again? Even just
So,
do a scenario, how you do one of them?
so what happens is that with the data protection impact assessment, right? This is something that the data protection officer would be best be able to assist you with. And what it really does is, say for example, you collect health information. And you have certain health information in your possession. And what you would do is try to set out what are some of the risks, in processing this type of information. What if there was supposed to be some sort of leak of this type of information, a certain diagnosis, right? What would be the type of damage that can happen? For example, if someone has been diagnosed with HIV, someone has been diagnosed with AIDS, right? There's a high level of risk there because of this type of information that you have in your possession. So what we'd have to do is you'd have to have it's a table that you would set out. There's a template that you also use, and you would state that this is the type of personal data that I have, health information, diagnosis. The risk level is high, so you'll select high. And then because it is a high risk level, you then have to say, what are some of the measures that I have put in place to make sure that this information is kept safe, confidential, and secure? And you have to list out those measures. And that's basically what the data protection impact assessment looks like, right? It's basically you set out the type of data you have, whether it's high risk, low risk, if there's a breach, and then what are the measures that you're putting in place to prevent any unauthorized or unlawful disclosure of this data or access to this data. And you'll have that set out in a document format, and then you'll have to submit that to the Information Commissioner.
Something you mentioned in your talk was that for doctors who are sole proprietors, you would encourage them to become a company?
No.
Registered? No? Oh.
No.
No.
You don't have to become a company.
It's something you said.
But
Is
you'd
it
have
that
to-
we'd be opening ourselves to more risk?
No, what I was saying was that you'd have to consider engaging a data protection officer.
No, you said it in regard to fines, and so
In regards to fines, as it relates to fines, because when I was discussing the fines, I mentioned what the fine would be for a company, for an entity, and that's up to 4% of your annual gross worldwide income. But being an individual now, being a sole proprietor, you can be fined as high as up to $5 million and or imprisonment if you're unable to pay. So I was just letting you know what the fines are as it relates to you.
Okay, thank you.
You're welcome.
All right, from the chat again, we have Christina Ramsey. Client files are kept in cupboards and shelves that are not very secure in all instances. Will it be my responsibility or the responsibility of the organization within which I work to ensure these measures are put in place to comply with the Data Protection Act?
So the organization within which you work would be the data controller. And so the obligation is on them to ensure that measures are put in place to comply with the legislation.
Right.
There's a hand, Dr. Richard Gomes.
Right, he had a question in the chat. I was getting to that.
Yes, the question was, you hearing me?
Yes.
Yes.
Yes, Dr. Gomes.
So if I have, I've been in practice for a number of years, 35 years plus, and I have a number of, obviously a number of patients. Do I now have to get consent from each one? Do I have to get consent from each one of these patients or consent form signed for data collection on behalf of these patients? Do I now have to go and seek them out and find them and make them come in to do it? Or do I do it moving forward? In other words, as I see them, then I get I get their consent.
Okay, so that's a very important question. So for those patients, right, that you would have been seeing prior to the legislation coming into play, how is it that you normally do your patient intake, right? Do they normally sign a patient intake form?
Yes, they would have signed a form on the front of the file, giving me the data information, name, address, age, etc.
And would they have been aware that this information was collected to provide them with a certain type of service?
I think it was just for the purpose of a record. I don't think they would have known that this information was for any particular type of service. I mean, they would know that I may need to send email messages or I may need to communicate otherwise with anybody. They just know that I have this information so that I can find the file when I next see them.
Okay. So what would happen then is in that situation, right? I mean, it may not be feasible to have to go and reach out to 100 and odd patients to try and obtain their consent. Right, thousands of patients to obtain their consent. So you have to understand that consent is one legal basis. I mean, it's one of the best forms of protection, but you also have another legal basis, which is legitimate interest, right, of your medical practice. And so in order to practice, in order to provide certain specific service, then this information is required to provide that service. So that is the legal basis that you would rely on as it relates to those patients where you would not have gotten their explicit consent to processing their personal data for a specific purpose. That's another legal basis you'll be able to rely on, which is legitimate interest of your practice, right? Because if it is that you do not have this information, then you would not be able to provide them with a specific service, I'm assuming, because you would need this information on them to provide them with the service. Right. And so that's what you'd be able to rely on. But another thing that you can also do is, as I stress a lot, is you would get your privacy policy in place. And this privacy policy in place would say that I collect name, I collect date of birth, I collect email addresses on my patients, I collect this information for these different purposes. And you can just let them be aware. You can have this privacy policy, I don't know, either sent out to them via WhatsApp, via email, if you have their email address, and you can just let them know that this going forward, this is how their information or their information will be used and how their information will be processed.
Yeah, well, that certainly that certainly will apply for some, but not for all patients, right?
Well, that would be for those who probably wouldn't have information.
Those kinds of facilities.
Communication channels. Okay.
Exactly. Some of them just have a telephone number, right? Others will have email addresses, etc. I mean, the more recent ones would have an email address or, WhatsApp, etc. All right. The next question is, I do medicals for, let's just say, a particular company abroad or an organization abroad, and I am just collecting the data for the purpose of satisfying that organization about this particular individual as to their fitness, right, to continue doing the particular job that they're doing. What is my responsibility here as far as this act is concerned?
So you're processing the data on behalf of those organizations.
I am collecting data. Yeah, on behalf of them, and then I will email the data to them.
Right. So you're collecting the data at their request.
Yes.
Because you're providing a service to them. So in that context, you would be regarded as a data processor and not a data controller, because the data that you're collecting is to provide them with the service. So you're basically saying that they don't give you the information. The information that you collect is not directly from them.
The information I get is from the patient.
It's from the patient.
I'm seeing the individual who has to satisfy particular requirements to be allowed to continue doing a particular job or providing a particular service. So once he satisfies these requirements, right, then that person is passed as fit, and this information is passed to the organization abroad, right? Because it's an
Oh,
international.
so that's a different, okay, so it's not a situation where the organization abroad is asking you to do this. It's a specific service that you provide, and a patient can come to you, ask you to do this, and then have that information sent to the organization overseas.
Yeah, essentially, yeah.
Right, so in that situation, you know, you would be seen as a data controller.
I'm the data controller.
Right, because you're the one who is collecting the information and you're the one that is providing the service. Because I'm assuming that the patient would come, they would pay a fee to you.
Yes.
And then you would rule whether it is that they're fit and proper. And then if it is that they are, you would send that information overseas.
Correct.
Right.
Yes. So I am a data processor.
A data controller.
Controller.
Right. In that context.
So, because I mean, I don't really keep any records. The records are kept. I mean, the records are kept by the organization that I am sending this information to. I am just collecting the data and I'm sending it to the organization.
So you don't keep the data any at all? I mean, it's
I mean, okay, so there, I mean, at the different, in one particular instance, I will keep the data, right? So I will have a record of them having done this particular medical at this particular point in time. In another situation, the data would be left online or in there. I can access it, right? And then after a period of 2 years, that will be removed by them. This is another situation. What is my role? In other words, again, I'm collecting information, I'm collecting data, and I'm then sending it on to an organization abroad or a company abroad. And if I wanted to access it again, I can get the number, go into their database, and I can bring down that information. But that will only remain there for about 2 years. What is my role other than I'm collecting data and giving it to them?
And you're not paid by the organization, you're paid by the patient.
Correct.
Okay, so I mean, because you can have joint data controllers and also, even if it is that the organization is seen as a data controller, you could also be regarded as a data controller because you would be collecting the data. So you would also be processing the data. You will be collecting the data, and then you'll be doing your fit and proper test. You will be receiving payment from the patient, right? It's just that you're providing this information to a third-party organization, an organization overseas, because you don't have to be storing the data to be regarded as a data controller. You know, once you collect the personal data, you'd also be regarded as a data controller.
So even though I don't have a record, I'm still a data controller.
But you said that you do keep records of it, because when you collect
Particular
information,
instance, I am not, in this particular instance, the last one I just spoke with you about, I am not keeping the record. The record is kept on their system, and I can access it online.
Okay, so
right?
you collect
I don't have any record.
So you collect the record and
I don't have to have a paper record. I can.
Okay.
The record is on their system.
So when you collect it, you input it into their system, their software.
Correct.
And you don't keep it.
Correct.
So
in that instance.
In that instance, then it's possible that you could be regarded as a data processor and not a data controller.
Okay. All right.
But one thing that I have to mention though is that the Act is relatively new. I mean, we have not received any guidelines. We have not received any regulations. So we haven't received any information as to how this piece of legislation would be interpreted and how it would be enforced in Jamaica. So we basically just have exactly what is set out in the Act, but not how it will be interpreted. So I'm hoping that, the government will do more as it relates to just advising the public and, issuing guidelines as to how the act will be enforced, as to how it will be interpreted, and that they will be in a position to answer, a lot of questions like this, because it's very difficult to say definitively how it is that they're going to treat individuals as to whether they will be regarded as a data controller, as to how they're going to be regarded as a data processor. We have no information, we have no guidelines. So it's basically a wait and see approach that we have to be taking right now, and hope that, very soon we'll be able to get more from the government as it relates to how it will be interpreted.
Thank you very much. Yeah, good.
All right, so in the chat again, we have Dr. Simone Chung. She says, good night. For doctors in private practices who uses Pharma Online's Daisy Health technology to keep medical records, would they register as a joint data processor?
Well, if who would register? If the doctors would register? Because it would be the
She's
doctors
asking
who...
if we, Pharma Online, would register with her as joint processors.
No, because what happening now is that it is you who would be regarded as a data controller, as in the doctor, because you're only using the Daisy medical records. Well, the Daisy medical records, are you talking about the medical records that you will get from Pharma? Pharma Online?
I think the data that they're inputting into the system.
Into Pharma Online, into the system. Right. So the data would really belong to them as a doctor, right? To the private doctors. And then they will just be using Daisy's platform, Daisy's software. So it is Daisy who would be seen as the data processor, but the doctor would be regarded as a data controller. And it is the data controller who's required to register, not the data processor. So there's no registration of data processors, only registration for data controllers.
I am good.
All right, we have a raised hand from Christina Ramsey. You can go ahead and unmute.
Hi, good night. Can you hear
Dr.
me?
Ramsey? Yes, I'm hearing you.
Good night.
Sorry, it's midwife Ramsey.
Oh, sorry.
Right. I am with the Ministry of Health, and one thing that comes across my area, a lot of times I have patients, they will ask me questions, they will send me video of things too, or pictures. So they see something happening with their baby or even with themselves, they may take a picture and they send it to me via WhatsApp, or they're asking me some questions, something is happening, and then I'll need to give them a reply or a response. So just checking how the act applies in such situations.
So you work with the government.
Right.
And as part of working with the government, you provide the midwife services.
Right.
And is there a system in place where, is it like, for example, when they send you photos, is it to work email? Is it to your work phone?
No, it's because we don't have a work phone, so it's my personal phone.
Do you have a work email?
We have one, but it's not fully implemented, so not able to use it.
Because what I would recommend is that, you would have them send, the information, the photos or whatever, to either a work email or to a work phone, and not necessarily to your personal email. Because in that situation, it's the government who you work for, who is the data controller. You as the employee, you work on behalf of the data controller, and you provide the midwife services. But then you're using your personal mobile phone, to receive images that are related to work. So I think it's a practice that you should, no longer participate in. I mean, you should see if you can get a work phone and have them send the images to the work phone or to your work email address.
Oh, okay then. All right, thank you.
You're welcome.
All right, and finally, in our question and answer segment, we have not a question, but a very popular comment that I would ask you to address, Samantha.
Okay.
It is from Dr. Patrick Robinson. And his comment is, in the real world of practicing medicine, no doctor can fully comply with even 1/2 of the requirements of the Data Protection Act. Every doctor will be made an outlaw by the act. The aims of the act are commendable, but in the real world of medical practice, the act is doomed by the virtue of its impracticality. The hours devoted to being compliant does not exist in the real world of medical practice. The act will take hours away from patients' care to the detriment of the patient's health.
Okay, so I can't say that I disagree with this statement, but we have to look at what is the purpose of the legislation, and it's to protect personal data, right? And it is also to protect your personal data, as a doctor. Whenever it is that you go and submit your personal information to whether it be a financial institution, whether it be a government institution, you want to ensure that they are protecting your personal data and that they're processing your personal data in a safe, secure, and confidential manner. So, as you said, the aims of the act are commendable. How are they going to go about enforcing it? That's something that we'd have to wait and see. In terms of how practical it can be enforced against medical doctors. I mean, you just want to try and put steps in place to ensure that whatever information you have, whatever personal data you have in your possession, that it is kept in a safe, secure, and confidential manner. And once it is that you implement those measures, once it is that you implement those procedures and those policies and you have them in place, I mean, I don't think it would be that, that difficult to maintain. You appoint your data protection officer, and your data protection officer will assist you. I mean, in ensuring that you're compliant, will assist you in ensuring that you have your policies in place, will assist you in ensuring that you have your procedures, and assist you in ensuring that you comply with those procedures and that you comply with those policies. So once you get your feet on the ground, once you implement them, and once you have those systems set up, I don't think it would be that difficult,
All right, let's see. Dr. Mario Guthrie, go ahead.
All right. Hi, good evening. Good presentation. You can hear me, right?
Yes, I'm hearing you.
My question is in relation to the data controller. And if you are a solopreneur as a medical doctor, right? I remember there being a mention of a conflict of interest. The data controller, there should not be a conflict of interest. What if you end up being the data controller? And I'm sure you being the doctor, there are millions of conflicts of interest. What if you can't hire a new person to come in and take that role? How do you go about that? Do I register as a data controller anyway? Or is that not recommended? And what if I do?
So you would have to register as a data controller, right? Being a sole practitioner, and being the person who collects the personal data and processes the personal data, you'd be required to register as a data controller. But if it is a one-man shop, right, where it is you alone, I don't believe you would be able to appoint yourself as a data protection officer. You would have to outsource the data protection officer, because there would be a clear conflict of interest there. You're the one collecting the data, you're the one inputting the data, you also cannot be the data protection officer. So you have to outsource the data protection officer.
All right, yeah, I have to go review everything. All right, so the data protection officer oversees the data controller, right?
Correct.
Right.
They oversee the data controller, and if the data controller is not complying with their obligations under the Act, they have a duty to report the data controller to the Information Commissioner.
And this is where I feel like the statement made by the previous doctor, I agree with it. But I also see where you're going and the importance of it. But it's It's a lot, that's all.
It's
But
a very onerous piece of legislation, I must say, and the government, I believe, need to do more in order to educate and inform and to sensitize, the public about it, especially since the fines are so substantial. I do agree in terms of how is it that it's going to be implemented, and it's going to be costly. I mean, it's going to be time consuming. I do agree. But I also believe that, once you get your feet off the ground, once you put all these policies in place, once you put all these procedures in place, it should be a smooth sailing after that. It's just to get it going.
I agree. I can slip in one more quick question. I know that filing cabinets and stuff should be locked, right? What if you have a room where all of these files are kept and the room is locked? Does that...
The room is not locked, but the files are locked. That's what you're saying?
I'm saying that the cabinets are in a room that is locked.
Good, and you? Nice.
So the cabinets are in a room that is locked.
Right.
All is well?
But the cabinets themselves are not locked.
No, not necessarily, right?
Okay, that should be fine. That's fine. I mean, once the room itself is locked and not everyone has access to that room, right? So you want to ensure that there's limited access to that room and that only individuals who have a need to access the room are allowed to access it.
Okay, no problem. Thank you.
Okay, you're welcome.
So Dr. Buckland had asked if DPOs are fined. So can a DPO be fined under the Act?
I'm not hearing you, Shani.
DPO, can a DPO be fined under the Act?
Yes, because the DPO has a duty under the Act to report breaches to the Information Commissioner. It's set out that it is their duty. And if it is that they fail to fulfill their duty, then they can be held accountable under the Act.
Okay. I believe Dr. Buckland wants to continue on that question. You can go ahead and unmute.
I have a situation where I'm dealing with a particular institution, and they sent me a form in which they want to do direct deposit into my bank account. So I'm supposed to provide certain information. And funnily enough, the person said I must get the bank to stamp the form, and I've never ever had to have a bank stamp the form. Just know that I would sign it and give my transit number. But the form also says, so the instruction, the thing at the top says, for the purpose of direct deposit. But then in the authorization section, it's more than direct deposit. So if their payroll makes an error, their payroll should be I give consent as well that they can go back into my account to retrieve whatever. And I said, but this is more than deposit, because if they're doing something, they need to be sure that they are accurate with whatever they are processing. So they are going beyond, to me, they're going beyond what the instruction was for direct deposit. And I just sent them a note and I said, no, I am sure this is in conflict with the current Data Protection Act.
Right.
So I refused to send it. So why don't you just pay me by check? Just pay me by check and call it a day.
Yes.
You agree with me?
Yes, so you always need to read the fine print. You need to read the documentation in its entirety, because you want to ensure that whatever you're signing to and whatever you're consenting to, you're fully aware and you agree with it. And as a data subject with the passing of this act, you have certain rights, And if it is that you don't agree with them using your data in a particular manner, right, then you have to point that out to them. Because, you know, as the Act says, you must only collect information that is relevant, that is required, that is necessary, and you must only use it for the purposes which you say you're going to use it for. So I agree.
So, you know, when I saw it, thank you. When I saw it like that, I said, you know, I can appreciate the importance of this act, because when I see how, say, even our utility companies and other service providers may treat data subjects, because on the talk shows every day, we hear it, you know, people are complaining, X, Y, Z. So I think it helps us to get our act together.
Yes.
So it's just a matter of going through the steps, the processes, and sharpen ourselves as best as we can.
Right. And you also have to bear in mind that, you know, by complying with this act, you're also complying with your international obligations, because I am not sure how many of you would be familiar with the European Union General Data Protection Regulation. And that's when you collect personal data, you know, belonging to EU citizens. And, you know, if it is that you do collect personal data belonging to EU citizens, you're required to comply with that piece of legislation, because even though you don't live in the EU, the act still applies to you here in Jamaica. And so you can also be fined under that legislation, you know, as it relates to processing personal data of EU citizens. So by complying with our local legislation, you know, you'll be complying with their international data protection standards as well, and data protection obligations as well.
One of my patients, well, don't reside here anymore. They reside in the UK, and asked me if I could send do a medical report and send it up so that they can use it for a certain process they want to do. And then I said, why no?
But I mean, you would have gotten his consent because it's at his request.
Yes, I know.
And it would have been sent directly to him, right?
I haven't sent anything. I just got it today.
Okay.
Why no?
Yes.
So I have to think about how I'm going to do that, you know?
Yes.
Oh, see, if apart from telling me to come down to Jamaica and get it. Because means I'm going to have to do certain things and make sure that it's, no, he's asking me to get it to this other person. I don't know who this other, he says that this person is who they say they are. I don't know. So he says they are.
It would be best to send it to him directly.
Ah, yes. Yes. I think so. And then he can send it to them.
All right.
Thank you so much for that. Thank you.
All right, we have another raised hand from Dr. Titus.
Hello, good evening again. So let's say that unfortunately a breach occurs. I want to go in that direction. What are the steps? Is it that the data protection officer will report the breach to both the doctor involved as well as the patient? Will it be done simultaneously? Or is it that the doctor gets informed first, the patient after? How does that work?
So the data protection officer would report the breach to the doctor who engaged the data protection officer. So he will report the breach to the data protection, to the doctor. And then you have a duty to report the breach to the information commissioner within 72 hours.
Right. So
you also have a duty.
Sorry, go
I was
ahead.
going to say that you also have a duty to report the breach to the data subject as well.
Okay. So meaning that the doctor involved would have to speak to the patient as well, or the subject involved, correct?
Right. So you'd have to notify them that there was a breach.
Okay. So that would have been done. And then the next step, let's say the fine, they say, okay, a fine has to be paid, whatever that fine may be. My question would be now, when that fine is paid, is it that the patient can still bring a suit to say, okay,
Yes.
so you'd have two things going on.
Because what will happen is that the fine is paid to the government, to the information commissioner. The fine is not paid to the patient. But what the patient would have to prove is that they have suffered some sort of damage as a result of the breach. It's not just by the mere fact that there is a breach, and just because there was a breach, they can be able to claim compensation. They would have to go to court and prove that they had suffered some sort of damage as a result of the breach.
But then, therefore, that means a doctor could end up literally having to pay two, what would I say now, two sums of monies.
That's correct.
Oh my gosh. That's incredible.
That's correct.
Oh dear. I'm trying to think what the other question was that I wanted to follow up with. So in terms of, okay, so let's say initially the patient was fine and said, okay, you know what, it's not a big deal. Yes, this breach happened, I haven't suffered. Is it possible for them to still bring a suit, let's say sometime after? So let's say 2 years later, they found out that somebody accessed their information through that breach, which they didn't know of at the time. So can they then bring a suit against you?
Yes, they can.
Okay. All right. Thank you.
All right, so I'm not seeing any new questions in the chat. However, I want to make mention of the link for doctors who have not yet done so. There is a link in the chat for you to complete a form that your CME certificates will be prepared and sent. So if you've not yet done so, click on the link, complete the form to get your CME certificate. For the raised hands, are these new? I believe we just heard from Dr.
Yes, Dr. Brown Morgan is new.
Right.
It's a new hand.
Go ahead. Dr. Titus, if you're finished, could you please remove? Right. Thank you. Go ahead, Dr. Brown Morgan.
Right. So I have two questions, comments in the chat, which have not been mentioned. And one is the comment on how would I manage the situation where, because you say that a patient can ask me to destroy their file. Now that just sounds like a whole nightmare to me, because why would a patient want me to destroy their file? And what if I did do this and later discover that there is legal consequences? Suppose I had seen them, and at the time I'd seen them, it was the information that I would have in my docket at that point in time was related to, with unknowing by me, to some case that is in court and I'm being called upon. For example, I had a case years and years and years ago where I was actually called as a witness in Miami-Dade County to testify. This policeman had murdered his wife over there, who he had serially abused out here in Jamaica. And I was called to testify several years after I'd last seen her. And that I'm just saying, what to do if I had gotten rid of that file before then, and also be clear, what do I do in the situation where a patient knows that this one, the poor lady died, but what do I do in a case where the person knows that there may be a situation coming, a court case, and I do that, and then I am asked by the court to supply certain information? I mean, how can I destroy a patient's file? This sounds to me like, I mean, this is not Jerry and nephew, and I purchased 10 cases of wine today. It's a different thing altogether.
Yes.
How can I do this?
Yes, I agree. So the rights of the data subject, they're not necessarily absolute, right? So what happens is that you can say that you're unable to destroy the file in the event that you need to exercise or defend your right to a legal claim. I mean, there are different reasons or different factors that come into play as to why it is that you need to keep the data or to hold on to the data. So once you can prove or satisfy that, you know, these are the reasons why I need to hold on to the data, whether it be for a legitimate interest, because as I said, there are a number of legal bases outlined under the legislation, one of which is if you need the data to exercise or to defend a legal claim. So you would have that legal basis to rely on as to why it is that you cannot destroy the data.
But suppose you don't know.
I mean, if you don't do, then that's a different, you'd have to destroy, you'd have to get rid of it if you don't do. If you can't.
No, I'm sorry. I'm saying if the patient is asking you to destroy the data ahead of you knowing the data will be required.
You'd have to rely on another legal basis. I mean, to comply with the legal obligations, that's one. The legitimate interest as a medical practice, it is in your own legitimate interest to hold on to this data. And even if you don't have, if you're not aware of a claim, right, at the point in time, you can say to them that I have to hold on to the data for as long as possible in the event that I need to exercise or defend a legal claim. You don't necessarily have to be aware that there doesn't have to be an existing claim for you to rely on that.
Okay, thank you.
So you,
the other concern was one, the fact that in order to comply with the wealth of information that you is being requested and keep it up to date, it seems to me that we won't have any time to practice medicine, especially when you're a sole proprietor. The whole thing seems quite cataclysmic. I mean, it just makes it impossible to be a physician, to be a good physician. It makes it more about documentation and maybe writing a prescription than being a proper physician. And something is being lost here. Lost. The services to the patient, the services, this thing that is being required of us needs to be refined in a big way in order to make it possible to work, to exist. And you know, it's and then the fees that are being asked. The fees that are being asked do not allow most sole proprietors to continue to practice medicine, especially the older ones. There are no fees that I've heard generally that would, outside of the huge multiple doctor general practices, allow for continued existence. And this is a real, this is not something being conjured. This is real. This is what is on our plate. And so we cannot be asked to do something which puts us out of existence. It means that something has got to give. It means that something has got to be done. Some changes have to be made, serious changes. Otherwise, many doctors, older, decent general doctors who serve this population massively will have to retire. I just wanted to just say that. I say it on behalf of many people who are listening right now, and some who have written in the chat also.
When you mention fees, what fees are you referring to exactly?
The data processing fees. The fees that the people who are going to, you cannot do, we're put in the position where we cannot do this for ourselves.
Okay.
We cannot ask a member of our staff to do it. And then the people who are out there to do it on our behalf, I mean, I have heard fees of $240,000 a month, discounted fees of $75,000 a month. These are monthly fees. There are and those are discounted fees, people tell us. It must be known and understood that a good 70% or more of general practitioners cannot afford those fees. So something will have to happen. That's all I want.
Okay, thank you for your concern, Dr. Brown Morgan. We will take one more short question because the meeting was supposed to end at 8:30, but we still have an overview of the system to get through and how Daisy Health Technology is compliant with the newly effective laws. So one more short question, and then we'll get into Daisy Health Technology. Dr. Buckland?
Oh, thank you so much. I was just thinking for some of us who practice and like do health fairs, and you have to collect certain type of data and so on for the persons. What we do is to just destroy it immediately, or just don't bother with any more health fairs. Finished. Done. Don't do any more. Let the government do it all. They don't want our services anymore. The Data Protection Act, yes, it's very important, but binding our hands, binding our hearts, we just will have to stop.
All right. Thank you for your input. Mr. Russell, could you please resend the link for the CME to the chat? And
Okay, I'm sending it now. Okay, it was sent. All right, Ms. Simpson, can I do the quick overview now?
yes, Mr. Russell, go ahead.
All right, good evening again, everyone. And we are way past our time. So let me just do a very, very quick overview of Daisy Health and what it is that we have in place already at Daisy, so that we can provide some confidence to those who are using the platform and those who are considering using the platform. Now, as you heard from the presentation, Daisy Health Technology, as a software company, the platform, we would be data processors. And so as data processors, we have a responsibility to ensure that our platform is secure. And so we have a number of protocols in place, encryption protocol, for example, of 2048 bits of encryption, meaning that if anyone should try to access information from our platform, they will only see numbers, letters, symbols, gibberish in essence. And so this now allows or prevents, I should say, individuals from accessing the data that is on the Daisy platform. The information is stored separately, and we use the Amazon Web Servers as storage. Now, the question has been asked many times, so why you don't use servers in Jamaica? No, because we No, none of the two companies that operate in Jamaica or any company at all that would say give server service has the capacity to host the amount of information that we have. So therefore, it is best for us to ensure that the information is stored on a reliable server system, and we have contracted Amazon Web Servers. Their servers are capable of handling the type of data that we have and how it is that this information needs to be accessed by the doctors. Access role is specific. So even at your practice, if you're a doctor, there are certain things that you can see and that you can do versus what your nurse can see and your nurse can do, what the receptionist can see and receptionist can do. A lot of doctors oftentimes will say to us, oh, but my nurse does this and my nurse does that, and I want my nurse to be able to do. We can't do that because that is how you might practice. But in order to maintain compliance, we must ensure that there are user-specific or user role-specific access so that the platform is compliant to what we have. Two-factor authentication so that, again, only the person who should have access can have access to the platform at your location. Now, it says here that we are compliant with HIPAA, OWSP top 10 certificates and ISO certificates. And I would want to even add that we have completed the majority of things that are needed for the Jamaica Data Protection Act. We are audited. We're audited 3 times per year, and as is requested by the auditing firm Valency Networks, and the link is here that you can go on and you can check out what Valency Networks is. And so in terms of the security of the platform, I mean, there's more that I could say, but because of time, I'm just going to focus on this part of it so that you know that Daisy Health Technology EMR platform is a secure platform that any physician can use and be sure that the information that they have for their patients are secured and you are in compliance with the Data Protection Act 2020. All right, so I'm going to stop there, Ms. Simpson. Thank you.
Thank you, Mr. Russell. All right, we've come to the end of our meeting, and I want to say a special thank you for everyone who has joined. And I want to give a sincere thanks to Samantha for taking time out of her busy schedule to be here with us today. Her dedication really shone through, especially her passion and depth of expertise. We want to reflect on the valuable insights we've gained from Samantha's presentation. I hope we can all carry forward the newfound knowledge
Ms. Simpson? Okay, seem we have lost Ms. Simpson. So let me just continue. I want to thank Samantha for her dedication and the passion that she showed tonight in her presentation, and the depth of knowledge that she, demonstrated that she has with this particular topic. It is a deep, complex, and not so clear topic, but I think she handled herself very, very well. And we're still waiting on government to complete a lot of things. And so that would make it even more complicated. But Ms. Moore did an excellent job, and I'm sure you all would agree with me that she did. You can contact her. Her contact information is will be made available if you want to contact her to talk to her some more about the whole the act, not a policy anymore, the act, and services that her company would be able to give. Now, if you have not yet done so, please, it's important that link that was placed in the chat for you to input your information. Yes, and it's going to be destroyed as soon as we have completed the process, but we need this information to create the certificates for you so that you can get your credits. All right, if we don't have the information, we won't be able to award the credits to you for this meeting. So thank you very much again for attending, and we look forward to hosting more meetings for you. And please enjoy the rest of your evening. All right? Take care, everyone. Dr. Buckland, yes, AWS is GDPR compliant. I'm going to leave the meeting open so that persons who did not click on the link can do so. But for those who have done so, you can leave whenever you're ready.
Thank you, guys. Thanks for having me. Bye, everyone.
All right, Samantha, we'll talk.
Okay.
Repeat, how do you get the CME credits again?
Could you repeat that? You're asking how do you get the credits?
Yes.
Oh, there's a link in the chat. If you just scroll back up, there might have some messages. Let me see if I still have. Let me just paste it again for you. Just complete. Click on the link and complete the information that's requested and submit. And we're going to send you the certificate.
Okay, thank you.
You're welcome. Just keeping the meeting open for a little while longer so that those who have not yet completed the form with their information, so we can send the CME certificates to you. You can do so now. So I'll be closing the meeting in another 5 minutes. So if you have not yet done so, please, again, just enter your information, click on the link, paste, I'm putting it in the chat once more, so you can all complete it if you have not yet done so. That is. All right, so if you have not yet completed the form, you can contact there. My number is on the invitation link, the invitation flyer that you would have received. So you can contact me after this. Please enjoy the rest of your evening, everyone.
And thank you very much. It's been a great evening.
Thank you very much, Dr. Anusha.
Yeah, it was good. Samantha did a marvelous job.
I think so too.
Yeah.
Yeah. All right, everyone. Take care.
Thank you.